Okay.
I'm still having a hard time hearing you.
The meeting started. This is the August 10 special meeting of the Harbor Management Commission. Here present in the room are Mark Foster, Harry French, Jack Herschler, Jeff Stedman, and Mr. Casey representing Mr. Owens. On the phone, I believe we have Ted Schwartzman, Libby Trischler, Betty Gabriel, Eric Sunman, are you there? Sam Cargill, are you there?
Yes, I'm here.
Okay, so Eric is present on the phone. Great. So this afternoon we are here having a special meeting under our Rule 23 whether or not the Harbor Commission and the Harbor Master have targeted Mr. Owens and subjected him to unequal treatment in denying his efforts to obtain a priority mooring permit. That was the assertion in Mr. Casey's letter of June 17th, 2021 to the Commission, and we are obliged to consider his request that we find that as a matter that the Harbor Master's denial of Mr. Owens' permit is contrary to law and that Mr. Owens is entitled to a priority mooring as a waterfront property owner. Under Rule 23, we have the authority and the obligation to review Harbor Master decisions when we have folks who have complaints about those decisions. We do not have the authority under our rules or under the Harbor Management Plan to usurp the Harbor Master's authority or to make decisions about stationing boats in the harbor. Mr. Casey, in that June 17 letter, as I said, has suggested that for a number of years the Commission and the Harbor Master have blocked Mr. Owens' efforts, denied his efforts to get a priority mooring permit in the harbor, when in fact I believe this year is the first year that Mr. Owens actually applied to have his name put on the waiting list. Under our rules and procedures, no one gets a mooring permit in the harbor who has not agreed to put their name on the waiting list and take the next available mooring. So it was not until this year that Mr. Owens agreed to have his name put on the waiting list, and his application to receive a priority mooring permit was considered as such by the Harbor Master. Mr. Casey says that the Commission spent a lot of time and too much effort and onerous and unnecessary information requests to try and determine that in fact Mr. Owens was an owner of the 789 Harbor Road property. I think we've been down that road before, and we agree that the corporate structure under which Mr. Owens applied for a priority mooring permit as a property manager is complex and not something that lay people or members of this Commission were easily able to understand. And since our rules require owners of littoral property to be the only ones who can assert the right to a priority mooring, it seemed absolutely necessary that Harbor Master determined ahead of time that Mr. Owens was indeed an owner and not an employee. That was what some folks thought when they heard the term property manager. Discussion at the last meeting, before our discussion at the last meeting, we received a letter dated July 13th from Mr. Casey with two new pieces of information. The first piece of information was a letter dated about 10 years ago from the chair of this commission at the time, Mary Von Kanta, and in that letter she stated to the engineers who were at the time revising, refurbishing, rebuilding the dock at 789 Harbor Road, that the dock would be used for the purposes of loading and unloading from a mooring permit. Also in that letter, Mr. Casey attached a portion of the Army Corps of Engineers survey that showed at the north end of the dock there are 2 to 3 inches of water at low tide. And during our conversation, the discussion came up whether or not it was appropriate for whether reasonable access, which is what our plan and DEEP says are the rights of littoral property owners, whether reasonable access to the water means access at all stages of the tide. And reasonable, to me, does not sound like means total. But the question is, what is reasonable access to the water? The other consideration about the use of the dock for loading and unloading vessels at the time, and we've taken a look at the plans that were submitted to DEEP at the time. The plans show that Mr. Hall, who was the owner doing the renovations of the dock, Mr. Hall had a 32-foot boat which drew 2 to 4 feet, and that the size of the boat and the draft of the boat and the positioning of the boat on the dock is very clearly indicated in the drawings, in the technical drawings that were submitted to DEEP as part of that project. So, here we are today. It's our obligation under Rule 23 to come up with a finding. We have the opportunity, according to our harbor management plan and I read the last sentence on page 639 of our plan, and that sentence is, the Commission should attempt to resolve those concerns without usurping the harbor master's authority, and then, if necessary, bring those concerns to the attention of DOT's Bureau of Aviation and Ports, which is the DEEP predecessor, for corrective action. So, Jeff?
Comment. When we wrote that section of the plan, so the plan comes first.
Jeff, could you speak up, please?
I'll try. I'm right in front of the microphone here, so.
We can hear you now.
All right. Well, when we wrote that section of the plan, which precedes the rules and procedures back in the early 1990s, we originally wrote it as that the Commission would act as an appeals board concerning decisions of the harbor master. We were then told in no uncertain terms by DEEP, which approves the harbor management plan, that there's no authority for the Harbor Commission to act as an appeals board of the harbor master, but that we could hear grievances or concerns or complaints, attempt to resolve them, and then if we can't, then as Chairwoman Taylor just said, we would then pass the matter on to the authority who the harbor master reports to. So that provision, the Commission should review actions by the harbor master and persons or organizations acting under authority of the Harbor Management Commission and Harbor Management Plan. So we give everybody an opportunity to express their concerns, but we don't have authority to overturn a harbor master's decision. And that was made clear at the time of the approval of the Harbor Management Plan. So any suggestions that this discussion now is a sham somehow because we can't overturn a decision or we're indicating that we can't overturn a decision by the harbor master is not correct, because we never had that authority in the first place, and DEEP recognizes that. So we're trying to learn and do what best we can to resolve issues. And if we can't, we can seek assistance from DEEP. That's my little background, because I wrote that originally and they told me it was no good.
So, commissioners, what would you like to do this evening?
So Jeff, what you just said, that's all that's occurred as far as you're concerned with this matter since our last meeting. Is that right?
I don't understand.
Well, is there anything else to report? Have you had any other discussions on the subject with DEEP, for example?
I thought DEEP is aware of this issue, and we have not formally asked DEEP in any formal way to clarify or to confirm our understandings, because central to this issue are assertions having to do with littoral rights and the rights versus public rights versus private rights. And we know that DEEP is the state agency that, in effect, if this is the right word, administers the public trust area and makes decisions concerning exercise of littoral rights into the public trust area. So they're aware of this decision, but we have not formally asked them in any formal way to confirm or clarify what our understandings have always been, reflected in the harbor management plan, that the littoral right is not an absolute right. It's not an absolute right to be determined by the person who wants to exercise the right. It's a right of reasonable access that's subject to reasonable restrictions, some of which are applied in DEEP's permit process.
Yeah, I do have a question. Earlier you said the words equal treatment. I think that's the allegation, I guess, is that there's been unequal treatment with this particular property owner. Is that, I guess, looking at Jeff as just as someone who has much more background as an expert on the harbor management plan, is that something that's part of our role as far as you're aware in the plan or otherwise?
Well, I have a personal comment to make about that, but I don't know if it's appropriate to hear Mr. Casey's.
My question is not in the context of this one particular matter. Really, it's more just a policy or just a question about my understanding of what our role is. So,
well, the role of the Harbor Commission from the beginning has never been to target anybody. For the 31 years or so that I've been involved with this commission and all the committee meetings, there's never been any example of anybody being disparaged or treated unfairly. The purpose of what we've been doing for 31 years is to manage the harbor properly and to address matters in a fair way.
Mark, is that your question?
Not really. I'm happy, though, to hear whatever he has to say, whether or not it is.
To jump ahead, the allegation that the commission somehow targeted the applicant illegally and targeted him in a discriminatory way is just not correct, because we've never done that with anyone over time. There's legitimate questions that arose as a result of this application, and the commission tried to address them objectively, not in any way to target someone or to rewrite the regulations specifically to deny him a mooring permit.
No. What I'm looking for more is, does it say anywhere, as far as you know, in the harbor management plan that one of the goals is for equal treatment in the way that the harbor is managed?
Well, we're following the principle of the Corps of Engineers of open to all on equal terms. That's one use of the term equal. But I think it just goes without saying, if we have a plan that's been adopted by a public agency for managing a resource, that it's implied that it would be pursued and implemented in a fair way. I mean, I think that's just a basic understanding or principle of good planning.
So I guess I'm not really looking for fairness. I think maybe I could just try to restate it. We have different harbor masters along the way, and there's plenty of cases that are unique, and the harbor masters are going to will be making their determinations as on a case-by-case basis much of the time. And so it just would seem to me, with just the change of people and with so many different cases, that applying, treating all cases equal, I'm not even sure that that's possible.
Because every circumstance the property's circumstances are different.
Sure.
The size of the boats are different.
Configuration.
Whether you are a waterfront property owner or a member of the general public, so there are guidelines and rules that we attempt to apply fairly. I mean, that's just an understanding of any sort of good government. You're not unfair.
Right. So,
but the situations are different.
When matters come before this commission, we're often considering, in our primary role, I think, is considering every matter relative to the harbor management plan. So I think that my job is pretty easy, which is why I'm not paid big bucks. I just need to consider each matter, look at the harbor management plan, and decide whether there's consistency. But that's a whole lot different, and I would say easier, again, than having to determine whether our determination is equal treatment to everything that's ever happened before, because I'm not in a position to know the answer because I don't have all the history, for starters. But moreover, I just don't see that as being my role. So now I'm showing my view, and where you can respond to that.
But you bring up maybe a discussion that's maybe broader than what we're talking about now, and the basic understanding of these plans is that it can't identify a solution to every matter that may arise. It sets forth policies and guidelines. If it did, there wouldn't be any need for a commission to have meetings and discuss these matters. You just open the book and say, okay, this is what we do. It says it on page 2-3. So there's interpretation in everything. It's part of planning.
Okay, thank you.
Mr. Casey, you want to be heard?
Yes, please. Thank
Okay.
you. Maybe I'll just check first that people on the phone can hear.
Can you guys hear Ed? Woody?
Yes.
Okay.
So, thank you. For the record, I'm John Casey. I'm a partner with the law firm of Robinson Cole. We represent the applicant in this matter, and I'll try to be brief. And this is just about a mooring, right? But it seems to have taken on a life of its own. Madam Chair, you started by sort of paraphrasing your interpretation of what we're here for. Now, I won't dispute that I think the history of Mr. Owen's interactions with the harbor masters, the former two harbor masters, reflects a pattern on their part. Maybe pattern is too strong a word, but to hold him to a standard and to make him provide information that we could find no evidence of in any of his records, in the office of this harbor master, that anyone else has ever been asked to provide a bunch of information about their LLC, or that any other dock owner who was applying for a priority mooring was ever asked to prove that the dock alone provided reasonable access. It was just given to them. So while I appreciate the point is we're not here to ask you to find that the harbor master, this isn't such a broad question as we don't want to implicate him into, that he's was acting with bad intentions or bad motives or anything. Really the question we're here for, as you pointed out, Madam Chair, we're asking for you on this appeal, on this application, 2021, to find that the harbor master was just simply wrong. He denied the application on the grounds that it was suitable for berthing a vessel of substantial size. We've shown you that at low tide there's 4 or 5 inches around this boat. I doubt there's anyone with a boat in Fairfield who would want to leave their boat at that dock 24 hours a day. It's just not suitable for berthing a vessel. I actually think this whole issue of reasonable access is a bit of a red herring. This is just about proper handling of a boat, proper berthing, proper mooring. DEP doesn't force dock applicants to leave their boat on the bottom at low tide. And I did have a conversation with Kevin Zavoy, multiple conversations with him. After this last meeting, I thought Mr. Stedman was going to call him. So I also called him. But apparently there was a change in plan on Jeff's part. I thought you were going to call Kevin. And I said, Kevin, let's talk about moorings and docks. I said, because my understanding is, and I've done this up and down the coast, I think I said this in our phone calls, but I understand phone calls aren't always the best way to get things across. Many, I might even say most, dock applicants get a dock that is not suitable for berthing a vessel of any size for 24 hours a day. DEP, depending on the circumstances, will say that 18 inches at low tide or less is appropriate. And why do they say that? Because they believe that every dock owner should have access to a mooring, that the dock, as this commission determined 10 years ago, is most suitable for loading and unloading passengers from a boat that's kept on a mooring. The mooring keeps the boat safe, it keeps the bottom from being scraped up, it keeps the boat from being knocked up against the dock. That's traditionally how this works. Kevin's point to me was that DEP would feel that if they could give someone a dock that you couldn't keep a boat on at low tide, and then the harbor master wouldn't give them a mooring, that there would be a denial of someone's littoral rights. When they say reasonable access, they believe that they don't have to give someone a dock that has 24-hour access. But it's the combination of the dock and the mooring that provides access. And I think it would be, crazy to think that a property owner who lives on the water, who has a property right that is distinct from every other person who doesn't live on the water, that specifically says and has protected in our jurisprudence for hundreds of years and in English jurisprudence before that, that the right to access your property from the water and to access the water from your property is a property right. And DEP has said that in decision after decision after decision. So if you can't access the water, what's the point of owning the land? You're in no better position, and there's decisions from DEP on this that says if you don't allow the property owner to have that access, they're in no better position than someone who lives on the upland. So it'd be ridiculous that someone who just happened to be a member at the yacht club next door has access to the water, and someone who lives on the water doesn't. So all we're asking this commission to do, and we're not saying we're not forcing you, we're not saying you have to give everyone 24-hour access. We know this property might not have 24-hour access because at some low tides, you're not going to be able to get to your boat, or your boat's not going to be able to get to the water. So the reasonable access isn't, all the time. We know that. What we're saying is that this dock can't be used for berthing a boat of any substantial size. And it's, I won't say mandatory, but it's reasonable. I'm only going to say reasonable. It's reasonable that as a waterfront property owner, which your harbor management plan, if you just want to look at your plan, recognizes as having littoral rights and recognizes as having the right to have a dock and or a mooring, that in that circumstance, when the dock does not provide reasonable access for berthing or mooring a boat safely, that person should have a priority right to a mooring. It's just consistent with your plan and with the way your harbor's been managed as far as we can tell. We look back 10 years at all the mooring permits. No one's ever been denied. No one's ever been questioned about whether their dock is suitable for the boat. As I said, they were just provided with a mooring permit. And whether, there was some discussion the last time, whether they were already in line and they already had a mooring permit, then they bought a waterfront property. Well, I appreciate that's a different circumstance, but your since your plan prioritizes littoral property owners, I don't see how you can say that Mr. Owens does not have that right to be treated and to be granted a priority mooring if his dock, as it does here, does not provide reasonable access. It does, and again, I think talking about reasonable access is a bit of a red herring. You can't safely berth a boat there 24 hours. No one would do it. No one would let their boat drop down into the mud. I mean, maybe someone would. I don't think a reasonable boat owner would. And have it sit on the bottom and come back up, bang against the dock. I don't see it. So, I mean, we can get into all these other issues, but I just think that the substance here is that this dock, which is the basis of the harbor master's denial, he says it's suitable for berthing a vessel of substantial size, and I don't think that's ever been the case. Madam Chair, you talked about the boat that Mr. Hall had. I would call that a vessel of substantial size. You couldn't berth that boat there. I don't think you could berth many boats, maybe a kayak, maybe a rib, but, you know.
No, that's not true.
So I would just ask, and I'll make one point about the history here. And I don't want it lost, but I don't want it to be overstated either. I mean, Tom Owens, it's all spelled out in my letter. One year it was, oh, you're just a stand-in for Ezra Field. The next year it was, you have, you know, your dock is suitable. You know, then it was, we need more information about the LLC. Then it was, no, it's your dock is suitable, without any evidence that the harbor master, prior to writing this year's letter, did any real investigation to determine that's true. So those are shifting reasons. That's put him, he's been made to do more. I mean, he didn't go out and hire a lawyer the first day he, you know, didn't get a mooring permit. He tried again. There was COVID, he tried again. You know, it's only when it reached a certain point that it just seemed like enough was enough. And this is only the first year we've come to this commission asking for relief. So I don't want words put in my mouth that I claim this commission has treated Mr. Owens unfairly. He's never made an appeal before.
It's in your comments, Mr. Tracy. You say the Harbor Master and the Harbor Management Commission have illegally targeted Mr. Owens and treated him unfairly.
By requiring the LLC information. But then that reason was dropped when we got the most recent letter. I think, I do agree. I mean, not that I agree with myself. I think it was that the fact that you didn't instruct the Harbor Master not to require that information on the LLC, I think that was wrong. But apparently he just made that determination on his own.
The commission has never instructed him to do anything. He is the one that determines whether it's suitable or not.
But when I filed my last appeal, the decision that I was told was that the commission took no exception to the treatment that Mr. Owen had received from the Harbor Master, which at that time was asking for all this additional information about the corporate formation of the owner of the property. So that's how it was left after I filed my first appeal and you made a decision. Then, I would say somewhat out of the blue, we got this letter denying the permit application on the grounds that the dock was suitable. So I think today we're here, and I don't want to get, I don't want to get stuck in the mud, for lack of a better analogy. I want to focus on the reason we're here today is that the last word from the Harbor Master was that this dock was suitable for a vessel of substantial size. I don't think that's the case. I think the evidence supports our position, and that as such, under your harbor management plan, Mr. Owens is deserving of a priority mooring as every other, not every, but everyone else who applied, as far as we can find, received. And that if it's consistent with your harbor management plan, you need to instruct the harbor master. I know there is no harbor master now, but I think you need to make a finding that your harbor management plan supports the granting of a permit, mooring permit, to the owner of 789 Harbor Road, and that when that seat is filled, the harbor master can do what he wants with that information. And then if we have problems after that, we have problems after that with the harbor master.
This commission cannot instruct the harbor master to do anything.
You can advise him as to the interpretation of your harbor management plan. I think your consultant just said that.
Jeff, you want to say?
Is it process now? One, no, I guess it's-
Kim?
This may be not a,
Libby. Betty? Libby? Who was that?
Yeah, this is Libby. I'm just, you know what, I'm listening as best I can to all of this. I've been reading everything as best I can on all of this. I feel like, you know, there have been lots of different subjects that have come up, and I feel like all of those subjects have been addressed. And now we have this subject, which that explanation that just came through on my phone sounds very legitimate from where I sit. But I guess I'm really just wanting to ask all of you on this commission. I don't have a vote, so I guess my voice doesn't really matter, but I am here as an alternate tonight to listen. I don't understand, to what end? What are we fighting for at the moment? This is a gentleman who bought a property with a certain understanding about that dock and the past owner who had the mooring in an LLC. This has been the way this has been forever. He's not trying to change the rules. He's not trying to do something that no one else has ever done. And this has taken up so much of our time and, frankly, from a layman's term, makes us as Southport Fairfield Harbor people almost look distasteful in my mind. This fighting and this counterintuitive battle to keep a mooring away from the owner of this LLC. And that's
Well, Libby, I think one thing that we've talked, you and I have talked about before, is that Mr. Hall, when he had the mooring, he did not jump the list. He was not a priority mooring permit applicant. He put his name on the wait list and he waited his turn like everyone else.
Right.
The difference here is that Mr. Owens is claiming that he is entitled to jump the list, and before 77 other people get an opportunity to get a mooring in the harbor, he's entitled to get one.
Right, and I understand what we've talked about, but now after just hearing this last piece, you know, priority right to a mooring, if you have a dock that a boat can't sit on for 24 hours, ownership, all of that, talk to me a counterbalance the conversation that we just heard, because it sounds to me as though he's not trying to jump a list. He should be, as a property owner, on the top of that list. He's not doing anything different than any of our other owners have ever done.
Well, I think the other concern that we have is there are a lot of folks who live upland who could assert littoral rights and the ability to have their right to have a mooring, and their property sits is mudflats for half the tide. And so what's the policy difference? Where's the moment? Where's the tide? Where's the guidance that says if you live up at the tide mill and you have mud in front of your house for 6 hours a day, that you're entitled to assert a priority application too?
Madam Chair, I'll just read from your harbor management. We're not asking for all those people. They can make their own claim. We're just saying,
Thank you.
your harbor management plan says each riparian property owner will be limited to one dock and or mooring immediately offshore of his or her property, provided that such dock or mooring does not interfere with navigation or cause a significant adverse impact on environmental resources. Never has anyone claimed that a mooring offshore of 789 Harbor will interfere with navigation. And I'd sort of look askew at that because there's been a mooring there with no such claim. Similarly, there's no claim that it's a significant adverse impact on environmental resources. Those are the standards that you will apply or should apply when a priority applicant, a riparian owner, asks for a mooring. And that's what the harbor master is obliged to apply, because he has to follow your harbor management plan. That's what the statute requires. So he has to apply this standard, and he did not apply this standard. Past ones have, when they granted Mr. Hall his mooring and gave him renewals when he did own that property. But you don't have to have been on the list to be a priority mooring owner. Because
Mr. Hall already had been on the list, and his name came up. So once you have a mooring, you can renew it every year.
Understood, but your plan doesn't require that littoral property owners wait on the list. Your plan provides that they get priority, opportunity, and right to a mooring if it does not interfere with navigation or cause significant adverse impact on environmental resources. All we're asking is that you apply the terms of your plan consistently.
Jeff, you were going to say before Libby?
I was going to say what you said, Kim. Look at that drawing. There's 7 or 8 docks that are upstream on the harbor. And if you accept the assertion that was just made that DEP supports every property owner having a dock and a mooring, then where would those people, if they hire their own attorneys, argue that they should have a mooring in the federal anchorage? And then there's less space for someone from the public waiting list. So I just feel that, and I, again, express myself that from having been involved with this for 31 years, it's just incorrect to say that the Harbor Master and the Harbor Management Commission illegally targeted this applicant for special treatment. And that just can't stand, because that's just not the case. The questions about ownership, maybe I'm not too smart, but if you look at one page, it says 789 Harbor Road owns the property. Mr. Owens is the manager of 789 Harbor Road. Mr. Owens has a leasehold interest. Mr. Owens has occupancy rights and an occupancy agreement, and Mr. Owens is a littoral property owner. Any sort of regular person that doesn't have like a big education would say, well, what does that all mean? So the harbor master is not targeting to ask those questions. He asked the questions. And the question about the one dock and or mooring, we weren't coming up with that in the rules and procedures to target Mr. Owens. We were continuing over the years to understand the responsibilities for providing public access to the harbor and to the Federal Navigation Project, and applying a principle of what reasonable access means, and that one dock and or mooring. It's not up to the applicant to say I want a dock and a mooring. It's a policy that would be applied. So yes, maybe you could make an argument that the policy could be applied in a different way. But it's just not correct to say he was targeted illegally and singled out for special treatment. And I just don't think that can stand. And if there are questions having to do with these assertions of littoral rights and reasonable access, then let's ask DEEP to confirm what our thinking, what we've always assumed to be those principles.
I'm making a statement on the record. I am an attorney at law. I'm required to be honest with this commission. I understood, Jeff, that you were going to talk to Kevin. You said that you would call DEEP, and because you questioned my interpretation the last meeting, which was exactly what I said here tonight. I had a long talk with Kevin, and I think maybe Deep doesn't want to get in the middle of this too much, but I think he would have answered your questions the same as he answered mine.
I talked to Mr. Zavoy's supervisor, Mr. Blatt, who said he was the proper person to speak to on this issue. And we talked in general terms about what reasonable access means, what littoral rights means, and he suggested that if we have further questions, we could put those in writing, and I said we would discuss them at this meeting tonight. So maybe the next step is to put those questions into writing to him.
Your rules have a 60-day deadline to rule on this. I'm telling you, I didn't write the rules. I'm telling you that Kevin Zavoy, who's been involved and who runs the Harbor Master program, he's the liaison in that program, told me that it would undermine the rights of littoral property owners if DEP gave them a dock that didn't have full access and then they were denied a right to a mooring. Because what would the point be?
What would also, if I might, what would also prevent the property owner from dredging around his dock? I mean,
Mr. Stedman can tell you, because we have just that situation in Norwalk. I would agree that actually he probably should have the right to dredge around his dock, but that's not what this property owner is seeking. He's just seeking what the prior property owner received and other property owners.
But the prior property owner already had a permit when he bought the house and did the dock.
The dock existed. The dock existed. The difference is that your harbor management plan, which you're obligated to follow, does not require a littoral property owner to wait on the waiting list. It gives special priority to littoral property owners. So every waterfront property that fronts the harbor could change hands tomorrow, and all those new owners could come to you next year, or to the harbor master, and ask for a mooring. And it would be improper to say you all have to go to the back of the line, because that's not what your harbor management plan says. It says you will give a priority to those owners.
So tonight you have addressed the issues that were in your letter about the claim that your client was targeted for discriminatory treatment by this commission and the harbor master. But then you also said that the issue at hand is the suitability of the dock. Is the issue that you are really addressing here the other issues which are, I think, causing some ire on the commission, or is it the issue about whether the dock is suitable for the vessel through the tide, and that your real question for us tonight is whether we find that the dock is suitable or not, whether there was an error made or that we should revisit that issue, because we're going round and round around issues around intent here, which you've sort of addressed, but then you go back to them again. It would be helpful for me to understand if the issue here, which you did say at one point in your remarks, is the suitability of the dock, or is that not the issue? Can we confine the conversation and your request to us tonight to the specific issue that you want to make, or is it an issue around that draws us into these other questions that become much larger for the whole commission?
And if Mr. Owens, if the determination is that Mr. Owens should be given a mooring permit at the property.
Right, again, given the caveat that this commission can't order a harbor.
I think this commission can make a finding that granting such a permit is consistent with your harbor management plan and can encourage the harbor master to issue such a permit. If that's the issue. The issue's always been, why isn't Tom Owens getting a mooring permit? After 4 years, one's mind, and not just mine, starts to wonder, what is it about Mr. Owens? What makes it different? What makes him stand out? So we want to make it, we need to address all the issues that have come up over the years. We wanted to make this commission aware of our concerns over Mr. Owens' treatment over the years. But the bottom line is that if he gets a mooring permit, with the support of this commission, the other issues fall by the wayside. We're not fighting for people up the river. We don't necessarily care about future precedent. We care about past precedent, and we think it supports Mr. Owens. And so the issue is, does granting a mooring permit comply with the harbor master? That a recommendation this commission would make to the harbor master when that position is filled. We would just like that put out there, and then we could deal with the harbor master.
I believe as short a time as maybe 3 years ago, there was, on that dock, there was about a 30-foot boat.
And that was addressed in my letter where I said he kept it, because he had no other option, Mr. Owens kept it at the dock thinking it might work, and it didn't work. It bottomed out at low tide. There was a couple of shoals approaching. He had trouble at anything past mid-tide. It was always a challenge to get to and from. So he kept it there, but it's not been back since. He wouldn't put it there again. He made other arrangements for his boat this year. I think that was the only year a boat was ever kept berthed full time.
I think the boat was there for 2 or 3 years, as I recall.
Mr. Owens has only applied since 2018, and then he only kept it there in 2019.
But I believe there has been a boat.
I can't speak to what the prior owner did, except I know the prior owner also had a mooring, so I don't know if he was able to keep a smaller boat there, and maybe he wasn't as concerned about the impact.
The boat that was on that dock was, I'm going to say, close to 30 foot.
Mm-hmm. I'll tell you exactly.
Yeah, I think we have pictures, Harry, of Mr. Hall's boat on that dock, but at what tide, I'm not sure.
And one of the reasons, as I recall, that was actually a very complex application because the foundation of that property is connected with the archway over Horse Tavern Creek, which the town owns. But I believe one of the purposes, and we can double check this, of pulling that dock a little bit back towards the property was so that the boat you talked about could be at the dock and not encroach into the federal anchorage. And I can tell you what the dimensions of that boat were or are.
So, commissioners.
9-foot beam, 32-foot boat.
I'm just curious, do we have on the table or somewhere a drawing with bathymetry for this location?
All we have is the Army Corps survey from last October with spot elevations, including 2 immediately adjacent to the float, that shows 0.3 and 0.4 feet at mean lower low mark.
Which is not inconsistent with the survey that's included with the permit application back in 2011 by the then owner of the property.
Right. But you know your harbor probably better than I'm sure there's been additional citations since the 2011 application.
Can I just say, from my perspective, counsel withdrawing the arguments that ill intent, however the mind wanders, as you said, what stands behind what we did, or that what the harbor master did, or suggestions that things that are addressed in properties near the tide mill dam somehow get drawn into this thing. If those kinds of remarks are withdrawn, my personal view about this would be different than the suggestions that were made about intent and also about the breadth. I'm happy to discuss the factual information that you've given us about this particular situation and focus our attention on that, because to me, that's a much more useful way to address this than the sorts of claims that were made in your letter to all of us. That's a personal view. But I didn't hear you suggesting otherwise.
No. The issue is whether the harbor master's decision, which is based on a claim that the dock is suitable for berthing a vessel of substantial size, to which there are no facts that support that, is a valid basis for denying Mr. Owens' mooring permit and is therefore inconsistent with your harbor management plan.
With regard to silting in of any property owner, the responsibility for bringing it back is going to also be the responsibility.
I'm going to turn this off.
Not the Harbor Management Commission or the town or anyone else to do dredging. That would be the responsibility of the property owner.
Dredging is a complicated subject, as I alluded to. Jeff and I are involved in a different manner in Norwalk concerning dredging around a residential dock, where we have a difference of opinion. Dredging is not an issue here. I would strongly urge that it not be an issue. It's the right to dredge and the ability to get a permit to dredge from a residential property. Dredging has a lot of issues related to it. As you know, just dredging a federal navigation project alone and disposing of those spoils are a major problem. I'm sure you're all aware of the Norwalk Cove matter. They received an inconsistent.
Excuse me for a moment. This is Libby again. Why are we coming up with alternative solutions like something as complicated as dredging? We can make a decision and find a solution with just dealing with the material and the information we have on the table right now, and by granting a mooring. I'm shocked that I'm hearing people talk about why doesn't the owner look into dredging. We all know how difficult that can be.
Libby, I think we are all struggling to find a solution, and I think that to suggest that something is off the table at this point is not quite fair.
So a mooring is probably the best solution. So why are we not discussing how we best go about that for this homeowner, as opposed to thinking I guess that's my question. And this
commission, as you know, the commission cannot direct the harbor master, when we have one, to provide a mooring. We can make a recommendation
based
on the plan, as Mr. Casey points out, but we cannot direct the harbor master to, nor can we say that that Mr. Owens has a mooring. That is a decision that's left to the harbor master when and if we have a new harbor master.
It's a fact. We can find that there's a 23-foot boat that is applied by someone who says he's the owner of the property, and we have documents showing that there are several inches of water at one end of this dock during the lowest tide. And those are facts. We can draw harbor master's attention when one is appointed by the governor to those facts, and the harbor master can revisit the decision of the previous harbor master relative to this mooring based on that. One possibility for our commission would be to acknowledge those facts, reject, in my opinion, the claims around discrimination and claims that all these properties up by the Tide Mill Dam north of the North Anchorage are somehow drawn into this particular case's fact set, and focus on those facts for the harbor master. My own view is that that would be the right kind of answer here, given the fact that we have no harbor master. Right. The only other alternative would be to embroil the state DEP in trying to address this in the absence of a harbor master named by the governor. But I don't think that's good for the town, and I don't think that's going to be good for this applicant either, to get a speedy resolution to this.
Ted, did I hear you?
Well, I was just gonna raise a point that Jack just touched upon in terms of getting the DEP involved. The meeting started out with Jeff saying that there was a mechanism in the harbor management plan for when the commission could not reach a decision. And it sounds to me like perhaps we're not at the point where we could reach a decision. And if that's the case, why would we not employ the mechanism that's in the harbor management plan in a situation like that? It was envisioned that there could be a point in time in which a decision could not be reached. There was a mechanism specified, and why wouldn't we use it?
I thought Mr. Stedman said that what's in the plan is actually contrary to law.
I think Kim read the part that he's referring to at the beginning of the meeting. I think
Right.
it was Kim who read that.
Right.
And I thought you said.
Oh, I thought it was Jeff. I stand
No,
corrected.
I don't think I
it was
ever
Kim.
said anything that's contrary to law.
You said you couldn't act as a board of appeals.
Yes, I did say that, and that was.
And you said, I thought you said that was in the original plan.
Well,
That was wrong,
oh,
but it shouldn't be.
I wrote it in a draft, and before it was approved, the DEP said, no, you can't put that in the plan. But this is what you can put in the plan, and that's what,
And
and that's what
And
Kim
this is what is
read.
in the
And
plan.
that's actually, I think, what I'm asking for. I may not have the chapter and verse quoted quite exactly, but you can act as,
We should attempt to resolve those concerns without usurping the harbor master's authority, and then, if necessary, bring those concerns to the attention of DEEP's predecessor for corrective action. That's in the plan.
so I think you could make a motion along the lines that was recommended, and you can actually forward that motion, I think, both to DEEP, as now the manager of the harbor master plan program, and to the seat, to the chair that is your harbor master, you know, that he will or she will fill at the appropriate time.
So any reaction?
Jack had I thought, at the beginning, and then Ted had something that we might want to add on to it.
Right.
Maybe there's but again, pardon me for saying this, and maybe it's after 31 years, but it would be my feeling that the commission should strongly reject the accusation that the harbor master and the harbor management commission illegally targeted the applicant for discriminatory treatment. The harbor master's not here to defend himself, but based on everything we know, that wasn't the case. And I think we might also want to say that we don't accept the assertions that the littoral right of the property owner guarantees the right of 24-hour access to navigable water. That's something that DEEP, I don't believe, has ever agreed to, and that's not the principle that we base the plan on.
Well, we're not asking for that.
Right, but you've made that assertion in these discussions. And the other thing is, I don't think that we want to accept the assertion that we've heard in these discussions that the littoral right includes a right to a mooring and a dock in all instances. That the littoral right is a right of reasonable access and not an absolute right. Then, Jack, you were, and maybe there's a way to go to DEEP and to confirm in a formal way our understandings of the littoral rights. But we haven't. We talked about it informally on the telephone. And then, Jack, you had your other part of your motion, which was to provide the facts of this matter concerning the water depths and to the incoming harbor master.
Right. It's not clear to me from what Kim read if DEEP wished to, they have the authority of a harbor master as I don't know if they can make that determination. Can they issue moorings in a town? I don't know if they can do that.
They can issue a permit. Every mooring is permitted through a general permit. It's either a harbor mooring or non-harbor mooring. Harbor moorings require approval of the harbor master. DEP could issue an individual permit for a mooring.
And we'd have
We talked about this with the governor's deputy counsel,
yeah.
And then we talked about it with DEEP as well. And there didn't seem to be much enthusiasm for DEEP taking over the harbor master's authority in an area where there is a harbor management plan. And as Mr. Casey stated, that there's a general permit for harbor moorings. And where that general permit applies, DEEP has delegated its authority to the local harbor master.
I mean, Mr. Casey's been listening to our calls and knows that we're working as quickly as possible to get applicants in front of the governor for assignment of a new harbor master. It seems like, given the time of year we are in, that it would make more sense to request that the incoming harbor master be the one to make this decision, so we don't end up with DEEP issuing one permit and 130 others being issued by the harbor master.
And I may be wrong, maybe they changed their mind, but when we talked about this with DEEP, they were not interested in assuming that the authority of the Southport harbor master.
Right.
So, what I have here is, so this might be the beginning of our finding, that the Commission strongly rejects the assertion that the Commission and the harbor master discriminated in any way against or targeted Mr. Owens, that we strongly reject the assertion that reasonable access is not 24-hour access to the water, that littoral rights are the right of reasonable access and does not include a dock and a mooring. Under our plan, it's a dock and or a mooring, and that we recommend to the new harbor master that he consider the new facts as outlined in the July 16th letter.
Yes.
The water depth and the letter.
Dimensions of the vessel that is applying to the application. Right,
and the letter written by Chairwoman Von Conta in 2011 that the dock is to be used for loading and unloading, and that so that the harbor master consider those facts set out in the July letter and the plan in reconsidering Mr. Owens' application when he or she is appointed by the governor. Do you want to add that we will formally then request opinion guidance?
Could I also say in your second point?
Yep.
Is about strongly rejecting the assertion about the littoral rights. Could we say not instead of strongly reject that we don't accept those assertions? Because there are questions and that's what we would like, I believe. We would also like the DEP we would like to formally request that the DEP confirm or deny, but confirm our understandings that littoral rights is a right of reasonable access. Our understandings of littoral rights based as presented in the harbor management plan.
And do we want to suggest that in our third point, our fourth point, when we're suggesting that the harbor master consider the new facts brought to light in the July letter, that the harbor master also consult with DEEP? Or is our formal request to DEEP,
I think that's
going to be sufficient?
The harbor master could always do that if he or she wanted to, but
Kim, I'm looking at this and I'm thinking also about what we did with the updated rules and procedures with respect to the open water, Long Island Sound facing properties. Right. What are we saying in this again? I'm just trying to keep those in mind.
Yeah, okay, so we're strongly rejecting the assertion that the Commission and the harbor master targeted or discriminated against Mr. Owens.
Okay, that's
one.
Okay.
Two, that we don't accept that littoral rights.
We don't accept the assertions. That one, the littoral right guarantees boating access at all stages of the tide, and two, that the littoral right guarantees guarantees a dock and a mooring in all instances.
Okay.
Then you feel like that covers us for the open water, people outside the inner harbor, potential claims in the future that the town should be installing a mooring for them, and those, we wrote language about the exposure they had for, it feels like.
Maybe the first part, that we don't, I'm sorry to be talking here.
Yeah, no.
Don't accept the assertion that 1, 2, that you wrote, and we reiterate our understanding that the littoral rights are rights of reasonable access and not absolute rights. And that gets us into.
Okay, and that gets us to the people with first of all, they're not immediately offshore. There's no moorings immediately offshore the property, for one thing, and also it's not reasonable.
Okay, and then, so that was 3, that littoral rights do not include dock and a mooring. It's a right of reasonable access, not absolute rights.
Yes.
Okay, that's the third piece of it. Yeah. And the fourth piece of it is that we recommend that the harbor master consider the water depth and the 2011 letter from Chairman Von Conta
Vessel dimensions
in reconsidering Mr. Owen's application. And that's 5, we formally request that DEEP confirm our understanding of littoral rights as they're set out in the harbor management plan.
The first part of your motion, could you read it again? Maybe we want to use the language that's in the letter to us, that the harbor master and the harbor management commission targeted Mr. Owens for unequal treatment.
Okay.
Unequal and discriminatory treatment.
Targeted Mr. for unequal and discriminatory
That's the language used in the
treatment.
Point. And I think that we can be proud that the harbor masters in Southport over the years have included Pat Carroll, Lou Schuler, and Ed Billings, who are all people of unquestioned character.
Right. Okay, so that's what I have written down. Do we have anybody?
I have a question. I mean, have we fully answered what we need to answer? So like I said earlier, I thought that my job was just saying whether or not the harbor master in this particular case, whether his conduct was consistent with the harbor management plan, right? And I'm not sure we said that in your points that I just heard. Do we need to, what I just said, do we need to include that, or am I off base?
Well, in point 4...
We made a finding. I mean, you want to add to the finding? I'm sorry.
No, go ahead.
I mean, our responsibility was to make a finding.
Okay.
And it's up to us to determine if the finding is expansive enough or says enough that we want it to, and we could make a number of other findings too. But it seems that these are...
Well, irrespective of whether this is one of the points that the chairperson's compiling, do we agree that the harbor, it sounds like we do, but do we agree that the harbor master in this case conducted the matter consistent with the harbor management plan?
Yeah.
And should that be said, or do we need to say it? It sounds like you say we don't. It's up to us whether we want
to. It's up to you whether to say that. I mean, that we found in the previous discussion about the previous, say, complaint or submittal, that the commission took no exception to the harbor master's actions, and I think that would be the same that we're saying now.
Right. I guess I feel we should include what I said.
Okay, so how do you want to say that, Mark? The harbor master conducted himself consistent?
Conducted the matter or handled the matter?
Considered the matter? Made his decision?
Consistent with the harbor management plan.
Mm-hmm.
Conducted himself made his decision?
Which covers, the information he requested and all the other steps he took.
And,
To me, I understand I believe I understand what his thinking was and the steps he took, and I can't put myself in his shoes, so I can't predict what how the next harbor master. So there's judgment applied. But judgment aside, it seems to me that he was in good faith conducting himself and succeeded in conducting himself in accordance with the harbor management.
I think that's a good statement.
So we could say, we could have as the first part of our finding that we found that the harbor master conducted himself in good faith and made his decisions consistent with the harbor management plan.
Yes.
Yeah, more than decisions, everything he did. That's why I said
Conducted himself, okay.
But
All right, conducted himself in good faith and,
In accordance with the harbor management plan. Consistent with.
And consistent with.
Or performed his duties, handled the matters.
We should check with the three folks on the phone. I think there's at least three of the commissioners on the phone.
Folks on the phone, can you hear?
We can, Kim, and I have one comment regarding your last point.
Good, go ahead.
And that is, your last point says that we're going to request of DEEP basically their position on littoral rights or their interpretation.
Right.
I think we should add to that we basically want the harbor master to consider DEEP's position or their input when they do their review.
Mm-hmm.
Okay, so as point 4, we would then say, where we recommend that the harbor master consider the water depth in Chairman Von Conta's letter.
Very good, yes.
In reconsidering Mr. Owens' application, but we would also add, would take into consideration the DEEP's advice.
The harbor master would take into whatever the outcome is of that last piece.
Right. What do we want to call that? DEEP's
guidance.
DEEP's guidance
DEEP's guidance
concerning littoral rights.
Right.
Okay.
Updated guidance, whatever. Up-to-date.
That's a good point.
Very good point.
Yeah, if they have a strong opinion one way or the other, the harbor master should definitely take that into account.
Yeah, good. Okay, Ted, that's good. We've added that.
Anybody else?
Anybody else have? Well, we should have actually had the motion and then discussed it, but we can go ahead and do it this way too.
I want to make it faster.
Anybody else have any thoughts or comments? In present or on the phone? Do we want to actually move this? Mark, you're moving?
Yes, I move that we vote to approve the, is it a resolution?
Finding.
A motion.
Motion?
Approve the motion.
Do I have a second?
I'll second it.
Harry seconds. Is there any more discussion? Okay, let me read it before we vote. So we all, and please correct me if I can't read my scroll.
The intention is to send this out in written form.
To DEEP and to the harbor master, yes.
To me.
Oh, to you? Oh, to the response.
As a response, I would recommend, you can ask your attorney, but I'd recommend a written.
Our secretary is on the phone, John, and so she'll prepare the minutes, and since it's a motion, I guess it would have to be prepared within a certain period of time.
Right.
But there'll be a written.
Yes.
Right, in the minutes, and certainly this is being recorded, so it'll be probably up on the website long before the minutes are available. Okay, so our finding, the first point, the commission finds that the harbor master conducted himself and performed his duties in good faith and consistent with the plan. Point 2, the commission strongly rejects the assertion that the commission and the harbor master targeted Mr. Owens for unequal and discriminatory treatment. We do not accept the assertions that littoral rights guarantee property owner access to the water at all stages of the tide. Second part of that, we do not accept the assertion that Littoral Rights guarantees a dock and a mooring in all instances.
Excuse me, Kim, is that point 3?
No, that's the second part of point
2.
of point 2.
No. Okay.
Point 2 has 2 parts.
You're renumbered.
Right. Point 3. I'm sorry, you're right. Point 1 was the harbor master conduct.
Yes.
Point 2 is we strongly reject the assertions that. Point 3 is what I just read. We don't accept the assertions that Littoral Rights guarantee access to the water at all stages of the tide, A, and 3B, that Littoral Rights don't guarantee a dock and a mooring in all instances. Okay, point 3.
Point 4 would be the request to DEEP for confirmation and clarification of our understanding of littoral rights.
Okay, so that's going to be point 4. We're formally requesting that DEEP confirm our understandings of littoral rights as set out in our plan. Point 5, is that right?
Yeah.
We recommend to the new harbor master that he consider the water depth and the 2011 letter signed by Chairwoman Von Kanta and DEEP's updated guidance concerning littoral rights when reconsidering Mr. Owen's application.
Were there more than just the water depth facts considered, including the vessel?
It was the,
vessel
Well, that's all
size?
in the application, so that.
it's the 2 points. It's the letter and the water depth.
Excuse me, Kim.
Yeah?
Is the water depth going to be considered not just the lowest tide, but the mean low tide, the moon tides, the seasonal tides, and the occasional storm?
We can just say available water depths at the dock. I mean, we're implying that it's all.
I mean, with the written documentation is the stuff that we've got here. If we find any others of updated, we could supply that too, but basically we're working with facts.
Right.
Right?
Pertinent
Whatever
pertinent
factual
facts
information
concerning
we
the
have.
water depth.
Right.
That's
Well, in this case, we're referring to that letter.
Right, it's got documentation, it's factual.
Right? Okay. So that's our motion. 5 parts.
Was there a another part that we added?
Well,
Which
we had as an additional part that littoral rights do not include. The littoral rights are not a reasonable access.
Ted's comment, though, was included earlier in the motion then, rather than at the end.
Yes,
Okay.
yes. We included that about that we'd ask the harbor master to consider DEEP's updated guidance.
Mm-hmm.
Which is 4. And that's
Which is
4 now.
Okay.
No, that's 5.
No, 5 was the harbor master should take the.
Yeah, but that was a part of that.
Okay,
I'm sorry to keep interrupting, ladies and gentlemen. The harbor master, who are we talking about? We don't currently have one, correct?
Right, and we can't, the new harbor master, we can't.
And do we have a timeline on that new harbor master?
No, Libby, no.
Right.
No. Let's not go there.
Okay, so I guess for my sake, and I just need to say it now, there are parts of this, I don't think all of these should be lumped in the same thing. Point 1 and 2, I would agree to. Number 3, I'd like to put on the record that I totally disagree with. Number 4 and 5, I will agree to, but I do believe that there has to be some kind of a timetable here. We don't even have a harbor master. So we're putting things out there with no end results, with no consequence to timing.
But Libby, we are not allowed. The law does not.
I understand.
allow.
I understand, but
There can't
I'm
be a
just saying.
timeline. We can't have a timeline.
Okay,
And the
fantastic.
the
So I
harbor master
get
affects
that,
all
and
the
all right,
foreign
thank you
entities in the harbor
for sharing that.
master's
I don't
jurisdiction.
believe all these should be lumped in the same process because I think they're all very different subjects, and I just wanted to go on record that I do not agree with number 3.
Okay,
Okay?
so
Thank
noted.
you.
So
Thank
noted.
you.
Any other discussion?
Kim, this is Ted.
Yep, Ted, go ahead.
I think Libby raises a very valid point in terms of time frame.
Okay.
Could we put somewhere in there that we would like a response from the harbor master? I don't know what's reasonable, 60 days, 90 days after that person begins. But not to give an unlimited time frame. Let's resolve this thing.
Well, I guess if I can just blurt out, I mean, I
Go
think
ahead,
that
Mark.
if we have endless delay with getting another harbor master, then we got much bigger problems in this particular issue.
Yeah.
So just kind of.
No, I don't mean 60 days or 90 days from now. I mean 60 days or 90 days from when that person assumes that position.
And what if we just, instead of giving them a deadline, just say that, or change this to say that they'll make a decision in a timely manner or something? I mean, the harbor master's not going to want to dilly-dally on this anyway. It's going to get a lot of attention. It's going to be in writing the first day they arrive, so. But maybe we say that they make a time number 5, their last piece, that they, in a timely.
That's fine.
Timely manner.
I mean, and we also don't know how long it's going to take Deep to get back to us either, so,
Right, I mean, yeah, we expect it to be quick.
You can't push deep.
I was hoping that the deep thing would be waiting for the harbor master when they arrive.
yeah.
but-
So are you okay with timely?
Yes, I am. And I hope Libby would be too, but she raised a valid point. We should resolve this.
Yes.
Oh, absolutely.
Yeah, I mean.
I don't think there's any
we're
intention
trying.
not to resolve it, it's just that we can't do anything till we have a harbor master, and,
We have a handful of mooring permit applications pending at this moment in the middle of the year. We have no other pressing matters for the harbor master in the online mooring system pending at the moment, but
Okay.
to everyone's point, come January, there'll be 130 other pressing matters, so
Right.
be good to get this
Right.
resolved.
That's right.
all right, so we'll say in number 5, we recommend that the harbor master in a timely manner consider the water depth letter and Deep's updated guidance in reconsidering Mr. Owen's application
Yes.
for a priority permit.
That sounds fine to me.
Okay. Libby?
That's fine, thank you.
Okay. All right. People ready to vote? We have more discussion. All righty. All those in favor?
Aye.
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 Great. Anyone opposed?
I'm opposed to number 3, so I don't know how I vote on 5 points when
Okay.
I am very opposed to one of them, so I guess.
Excuse me,
I'm
alternates do not
All right.
vote?
Alternates
Okay,
have no
great.
vote, unfortunately, Libby, but thank you for your
That's
opinion. Okay, thank you. Okay,
Can you please tell me who we have in favor?
sure. Jack, Mark, Harry in the room, and Ted on the line.
Okay, thank you.
What about you?
Well, I am, but I
Oh.
can't vote unless there's a tie. Anything else? Anything else we need to consider this evening? Then could I have a motion to adjourn? Mark? Mark moves, Jack seconds, we are adjourned.
Thank you.
Thank you. Thank you, everyone.
Thank you.
Good evening, everyone.
Bye.
Good night.